Hi, hello. I'm Dr. K. Pungode, Assistant Professor in Department of Commerce. Now we are going to discuss about the topic formation of a contract in the subject commercial law. Before slide, we have discussed about what is contract, what are the essentials of a contract, and what are the classifications of contract over here. Now we are going to discuss about the formation of a contract. The formation of a contract refers to the process by which a legal binding agreement comes into an existence between a two or more parties. So that is known as formation of a contract over here. Before going into the formation of a contract, we should have if we make a contract means we should know about who is an offerer and who is an acceptance over here. Though here if we want to have a valid contract mean, first thing is that offer and acceptance is the most important thing. Now we are going to clearly understand about what is offer. An offer is a proposal made by a one party, the offerer, or to another party, the offeree, expressing the willingness to do or not to do something with the intention of obtaining a consent of an others. So that is a offer. If we are having an offer means, if one offer should be valid means it should be clearly proposed and it should be clearly communicated and it should have create an intention to create a legal relationship over there. So these are all the most important thing in an offer. Example for an offer is A offered to sell his laptop to B for rupees 30,000. This is a valid offer, that is known as an offer. The next thing we are going to see about the acceptance. Here acceptance is an unconditional agreement to all the terms of a offer by the offeree. Acceptance must be communicated and it should be an absolute one. So that is an acceptance. Here the example, B agrees to buy a laptop for rupees 30,000. This is an acceptance. Here we are having a offer and acceptance. Offer means A is offering a laptop for rupees 30,000. Here acceptance means B is agreeing to buy the laptop for the rupees of 30,000. This is an acceptance over here. So next thing is lawful consideration. Here the lawful consideration should have a certain essential valid contract over here. So the essential valid offer means it must be clear and defined. So it must be communicated to the offeree. It shows the intention to create a legal relation. It should not be a vague one. It must be expressed or an implied form. That is oral or a written format. So that is an offer. Here we are having a different types of offers over here. So the first type is general offer. General offer means made to the public at a large. Example, reward for finding a lost dog. So that is called a general offer. The next thing is a specific offer. In this it is made for a particular person. So that is known as specific offer. Example, A offers to sell his bike to B. Here A is offering to sell his bike only to the particular person, that is B. That is special offer. Next thing is express offer. In this express offer made by the word or spoken or a written. So that is known as express offer. Next thing is implied offer. In this implied offer inferred from the content. So here implied means it should contact something over here. So that is implied contract or say I have to perform. Next one is standing or continuing offer. Opening for a period of time. Some offer may be open for a period of time. That is known as period of time offer. The next thing we can see acceptance. Here the acceptance is an uncount to accept an offer. So here if we are accepting an offer means we have to make it clear about this. Acceptance is the unconditional assent given by the offeree to terms of the offer, which is when a person to whom the proposal is made signifies his assent, the proposal is said to be accepted. So here we are having some essential point over here. This the acceptance should follow the following elements. The first thing is that acceptance must be absolute and unqualified. It should be communicated to an offerer. It must be given within the prescribed or a reasonable time. it must be given by the offeree and it according to the mode of prescribed form. These are all the valid acceptance over here. These are all the content we should have in a valid acceptance. So the next thing also, in this also we are having a different kinds of acceptance. One is expressed acceptance, other one is implied acceptance, and the third one is conditional acceptance. Here the express acceptance means by spoken or written words. If acceptance is acceptable, that is express acceptance. Implied acceptance means by conduct, only in the form of conduct is known as an implied acceptance. Next one is an conditional acceptance. In this acceptance, subject to the condition, some conditions is specified over here, so that is subject to condition, not a valid acceptance. Here communication of offer and acceptance. Offer is completed when it comes to the knowledge of an offeree. Acceptance is completed against the offerer and acceptor. So that is here I conclude with this. The offer and acceptance together create a mutual concern. Without any valid offer and acceptance on contract can be formed. So that is a valid contract over here. Before the formation of a contract means both offer and acceptance should have, they have to follow the certain rules and regulation. That is a valid contract element is essential for this. And then we are having a types of contract we have seen over here, and also types of offer and acceptance. Thank you. I hope you all understand about the formation of contract.